Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Dealing with Discrimination and Retaliation Claims. Dealing with discrimination and retaliation claims is a critical component of human resources management, particularly in California, where employment laws are stringent and comprehensive. As HR professionals striving to master the PHRca Certification, understanding the nuances of these claims is essential. This lesson will explore the nature of discrimination and retaliation in the workplace, the legal frameworks governing these issues, practical steps to prevent and address them, and the implications for both employers and employees. Discrimination in the workplace occurs when an employee is treated unfavorably because of personal characteristics that are protected under federal, state, or local laws. These characteristics include race, color, religion, sex, national origin, age, disability, and genetic information. According to the Equal Employment Opportunity Commission, in 2020 alone, there were 67,448 charges of workplace discrimination filed in the United States, with California being one of the states with the highest number of complaints. California's Fair Employment and Housing Act extends protections beyond federal law, covering sexual orientation, gender identity, gender expression, marital status, and military or veteran status, among others. Retaliation claims arise when an employer takes adverse action against an employee for engaging in legally protected activity. Such activities include filing a discrimination charge, participating in an investigation, or opposing discriminatory practices. Retaliation claims are the most common type of discrimination charge filed with the EEOC, accounting for 55.8% of all charges in 2020. In California, it also prohibits retaliation against individuals who assert their rights under the law. To effectively address and prevent discrimination and retaliation, employers must implement robust policies and training programs. This begins with a clear anti-discrimination and anti-retaliation policy that is communicated to all employees. The policy should define prohibited conduct, outline the procedure for reporting complaints, and assure employees that retaliation will not be tolerated. Training programs should educate employees about their rights and responsibilities, and managers should be trained on how to handle complaints appropriately to avoid retaliation. When an employee files a discrimination or retaliation complaint, it is crucial for the employer to conduct a thorough and impartial investigation. This involves interviewing the complainant, the alleged perpetrator, and any witnesses, as well as reviewing relevant documents and evidence. The investigator must remain neutral and objective throughout the process to ensure a fair outcome. According to the Society for Human Resource Management, a well-conducted investigation can mitigate legal risks and demonstrate the employer's commitment to a respectful workplace. Employers should also consider alternative dispute resolution methods, such as mediation or arbitration, to resolve complaints. ADR can be a cost-effective and less adversarial way to address disputes, fostering a more collaborative resolution. The success of ADR depends on the willingness of both parties to participate in good faith and the skill of the mediator or arbitrator. In addition to internal policies and procedures, HR professionals must stay informed about legal developments and case law related to discrimination and retaliation. For example, the U.S. Supreme Court's decision in Burlington Northern and Santa Fe Railway Co. v. clarified that retaliation claims do not require a tangible employment action, such as termination or demotion, but can include any action that would dissuade a reasonable person from making a complaint. Understanding such precedents is vital for ensuring compliance and protecting the organization from liability. Preventing discrimination and retaliation also involves fostering an inclusive workplace culture. Employers should promote diversity and inclusion initiatives that go beyond compliance, creating an environment where all employees feel valued and respected. Research by McKinsey & Company has shown that companies with diverse workforces are more likely to outperform their peers financially. Cultivating a culture of inclusion can reduce the incidence of discrimination and retaliation, as employees are more likely to engage positively with one another. Moreover, employers should regularly review their policies and practices to identify and address any potential biases. This can involve conducting pay equity audits, reviewing hiring and promotion practices, and ensuring that job descriptions and performance evaluations are free from discriminatory language. By proactively addressing these issues, employers can create a fairer and more equitable workplace. It is also important for HR professionals to provide support to employees who experience discrimination or retaliation. This includes offering resources such as employee assistance programs, providing referrals to external agencies or legal counsel, and ensuring that the employee feels heard and supported throughout the complaint process. Supporting affected employees not only helps them cope with the situation, but also reinforces the organization's commitment to a respectful workplace. For employers, the consequences of failing to address discrimination and retaliation claims can be severe. Legal penalties can include substantial financial damages, legal fees, and reputational harm. For example, in the case of Diaz v. Tesla, Inc., a jury awarded a former employee $137 million in damages for racial discrimination and retaliation, highlighting the significant financial risk to employers. Beyond financial costs, failing to address these issues can lead to decreased employee morale, increased turnover, and difficulty attracting and retaining talent. In conclusion, dealing with discrimination and retaliation claims requires a comprehensive and proactive approach. HR professionals must implement clear policies, provide thorough training, conduct impartial investigations, and stay informed about legal developments. By fostering an inclusive workplace culture and addressing potential biases, employers can create a respectful and equitable environment that benefits both employees and the organization. The stakes are high, but with diligence and commitment, HR professionals can effectively navigate these challenges and contribute to a positive workplace culture. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.